Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today let us move to the new topic nationality. Individuals of a particular nation are supposed to owe allegiance to their states. Such individuals who owe permanent allegiance to a state are known as nationals of a state. Nationality may therefore be defined as the status of a natural person who is attached to a state of allegiance. Thus, the term nationality is nothing but a legal tie between the individuals and the state. Here, allegiance is nothing but some kind of commitment or loyalty or kind of fiduciary relationship between the country and the person. Oppenheim has very strictly stated that the nationality of an individual is his quality of being a subject of that state. Nationality is the medium through which an individual can enjoy the benefits of international law. A state exercises jurisdiction over its nationals, traveling or residing abroad, remain under its personal supremacy. International law permits the exercise of such jurisdiction and sets the limits within which it can be exercised. There is one case in which Matomatis case where the Permanent Court of International Justice observed that it is the elementary principle of international law that a state is entitled to protect its subject when injured by acts which are contrary to the international law committed in another state from whom they have been unable to obtain satisfaction through ordinary channels. The right of protection extends and also the property of the national as well. Further, if a national of a state is expelled from a foreign state, it becomes the duty of its own country to receive back its nationals. The refusal to receive and expulsions of the state's own national are inconsistent with the international law as they may involve a burden on other states which are not bound to undertake. What is the international importance of being or having a nationality? The protection of rights of diplomatic agents is one of the consequences of nationality. If a state doesn't prevent offences of its nationals and allows them to commit such harmful acts, it might affect other states also. Then the state shall be responsible for the acts committed by such person. Ordinarily, states do not refuse to take the persons of their own nationality. By nationality, we may mean loyalty towards a particular state. Another effect of nationality is that the state can refuse to extract its own nationals. According to the practice of a large number of states during the war, enemy character is determined on the basis of nationality. States frequently exercise jurisdiction over criminal and other matters of the persons based on their nationality. So we have 8 modes of acquisition of nationality, and a person may acquire the nationality of a person in accordance with the rules of its own country's municipal law. It implies that the municipal law determines as to who may be a national of a particular state, and it differs from state to state that how is the mode of acquisition of the nationality. Mode of acquisition by birth. Nationality is conferred to a person by many states on the basis of birth. Although many persons whose birth takes place within the territorial limits of a state acquire the nationality of that state, and this principle is called jus soli. The Indian Citizenship Act, in that under section 3, it has provided about the jus soli on the basis of birth by descent. Nationality of a state can also be acquired by a person on the based on the nationality of either of the parents or both the parents. Thus, the child may become a national of that state of which his parents are nationals. This principle is known as jus sanguinis. And in Indian Citizenship Act 1955 under section 4, it is written, a person may be an Indian national or on the basis of the principle of jus sanguinis. By naturalization, a person may acquire nationality through naturalization in different ways, like through marriage, legitimation, option, acquisition of domicile, appointment as government official, and grant of application. Adoption of children by parents who are nationals of other states also entitles the children to acquire the nationality of his parents. By resumption, a person who has lost his nationality by naturalization or by any reasons may acquire the nationality of the same state again. This process is nothing but by reintegration or resumption. Subjugation. A person may acquire nationality through subjugation after the conquest. When part of the territory of a state or a state itself is subjugated by another state, all the inhabitants of the territory, obviously they become the nationals of the next conquered state. By cession. When a part of the territory of a state is ceded to another state, all the nations of the former state acquire the nationality of the latter state. By option. When a state is partitioned into two or more states, the nationals of the former state have an option to become the nationals of any of the successor states. The same principle applies in the case of exchange of territory also. Next is by registration. A person may acquire the nationality of a state through registration, and this process of registration may be different from one state to another depending upon the municipal laws of the state. We learned how to acquire the nationality and what are the modes, and we also have to learn about how loss of nationality also occurs. By release, some states give their citizens the right to ask to be released from their nationality. Release occurs only when an application is made to the effect and if it has been accepted by the state concerned. By deprivation, a national of a state may be deprived of nationality in case of certain happenings. Legislation of many states recognizes numerous grounds of deprivation of nationality. What are the grounds? If, for example, if a citizen enters into a foreign civil or military service without the permission of its own country, then he may be deprived of the country or deprived of its nationality. By renunciation, a person may renounce his nationality of a state. The question of renunciation of nationality arises when a person acquires it from more than one state. By substitution, a person may lose his nationality of a state when he acquires the nationality in some other state by naturalization. By expiration, a person may lose the nationality of a state by expiration. For instance, some state has provided legislation that citizenship expires in case if he has left the country and he has been in certain other country for a prolonged period or certain length of time. By subjugation, a person may lose his nationality through subjugation after the conquest when part of the territory of the state or state itself is subjugated by another state, then all the inhabitants of the defeated state lose their nationality. Same in the case of cession. When part of the territory of a state is ceded to another state, all the nations of the former state lose that nationality of the former state.